Good morning, and thank you for your time and your commitment to such a worthy undertaking. I'm Greg Merriweather, welcoming you to this year's Angola Museum Symposium on Race and the Louisiana Criminal Justice System. Our founding fathers, in establishing the new Constitution of the United States government in 1789, committed to the goals of forming a more perfect union and establishing justice. As for equal justice, with regard to race, well, that wouldn't really start to appear until some 80 years later with the 14th Amendment. It, though, would be another 100 years before we'd see the enactment of groundbreaking civil rights legislation. The struggle of African Americans to get full rights and be valued as equal to whites has been an enduring struggle, to say the least. A critical component of that struggle has been the often painful relationship between African Americans and the criminal justice system. Of course, equal justice under the law is a fundamental guarantee of the Constitution and American democracy, but yet in the real lived experiences of some African Americans, equal justice has been more of a constitutional promise than an achieved reality. The historic U.S. Supreme Court case in 1896 that ruled blacks did not enjoy citizenship rights equal to whites, of course, originated in Louisiana, the now infamous Plessy versus Ferguson. Until recently, Louisiana was one of only two states, with Oregon being the other, that did not require unanimous jury verdicts for criminal convictions. You don't need me to tell you that Louisiana has the highest sustained rate on incarceration in our nation. In fact, Louisiana leads the nation in no parole sentencing. As of last year, about 16% of our state's prison population consists of inmates serving life without parole. That is the highest percentage in the nation. This brief summary of racial dynamics in our state and nation provides a terrific segue into the Angola Museum's efforts today. The title of the symposium is In Pursuit of Equal Justice, Race and Criminal Justice in Louisiana, Reconstruction, Convict Leasing, Jim Crow Governance, and Prison Reform. Museums have an ethical obligation to educate the public on great issues of human affairs in our society. Now, consistent with that obligation, the Angola Museum, in its symposium, seeks to foster a discussion that accurately depicts what we've been through and where we hope to head. There is a lot to learn from Louisiana's painful history regarding race and the state's criminal justice system. The goal, though, is to create a criminal justice system which everyone will be treated equally. So I invite you to not just sit back and enjoy, but sit up and be engaged. This morning can be a start we all need. Thanks again for your time and your attention. And now we turn things over to your moderator.
Good morning, everyone, and thank you for joining us today. Welcome to In Pursuit of Equal Justice, Race and Criminal Justice in Louisiana, Reconstruction, Convict Leasing, Jim Crow Governance, and Prison Reform. We'd like to thank you all for joining us today, as well as all of our panelists that we have here, who are extremely excited to have with us today. I would also like to thank everyone behind the scenes that has had a huge effort in putting this on together today. So thank you for joining us as panelists discuss the facets of racial history during the Jim Crow era and the effectiveness of recent justice reforms aimed at producing a more just criminal justice system for all Louisiana citizens, particularly African Americans, and suggest ideas about what equal justice could look like in the future. Today's panel examines the recent reforms in the Louisiana criminal justice system undertaken by Governor John Bel Edwards and the Louisiana Legislature to reduce the level of mass incarceration in the state and the factors which led to those reforms. Funding for 2021 Rebirth grants has been administered by the Louisiana Endowment for the Humanities and provided by the National Endowment for the Humanities as part of the American Rescue Plan and the NEH Sustaining the Humanities through the American Rescue Plan initiative. The views, findings, conclusions, or recommendations expressed in this symposium do not necessarily represent those of either the Louisiana Endowment for the Humanities or the National Endowment for the Humanities. Before we begin, there's a few items I'd like to go over. There will be time allotted at the end of presentations for questions and discussions. If you have a question for a panelist, please submit it into the Q&A segment at the bottom of your screen on the menu. For any general questions or information about upcoming panels, technical issues, or general information, please type your comments in the chat and one of our support members will respond to you. At this time, I'm going to introduce our moderator for today, Dr. Reginald Owens. Dr. Owens is the retired chairman of the Department of Journalism at Louisiana Tech University, where he held the F.J. Taylor Endowed Chair of Journalism. He has taught mass communication at Grambling State University, Texas Southern University in Houston, University of Texas, Houston-Tilson University, and Austin Community College in Austin, Texas. He has also worked as a reporter and editor in Houston. Thank you so much today. Thank you so much for being here, Dr. Owens. We really appreciate it. And I'm going to pass it on over to you. Thank you.
On mute.
Thank you. Thank you very much for inviting me to be here. And I want to applaud the Angola Museum for the efforts that they put in to discuss this important issue. I think it's a very good issue for us to look at. And with our esteemed panel here, we'll get right down to it. I'll say this to our panelists. You have a time of 10 to 12 minutes, and I encourage you, plead with you really, to stay within that as much as you can. And if it gets too far afield, I'll gently nudge you to try to get you back in. Our first panelist is Representative Royce Duplessis. Royce Duplessis was elected in the spring of 2018 to serve as state representative for District 93 in New Orleans. District 93 includes Central City, Central Business District, Lower Garden District, French Quarter, Lower Mid-City, Treme, 7th Ward, and St. Roch neighborhoods. Prior to serving in the legislature, he worked as special counsel for the Louisiana Supreme Court and served as chairman of the New Orleans City Planning Commission. Royce is a past president of the Louis A. Martinet Legal Society. Since 2012, he has volunteered as a mentor to male teenagers through the nationally renowned Silverback Society. Royce ran for public office in order to better serve those who are underserved and marginalized, with a focus on living wages for the working class, increased access to quality early childhood education, and smarter criminal justice policies. His committee assignments include House and Government Affairs, Vice Chair, Commerce, House Executive Committee. Royce is a graduate of St. Augustine High School, Xavier University of Louisiana, and Howard University School of Law. He is a practicing attorney and operates a solo law practice with a focus on civil litigation. He is married to Crystal Furbus Duplessis, and they are proud parents of one daughter, Reese. They reside in Central City. Representative Duplessis.
Thank you, Dr. Owens. I don't know if that introduction cuts into my time, but next time I will be sure to submit just a one sentence bio. That's all you need. I'm a state rep. That's from New Orleans. That's probably all that was necessary. But just a few points, because I have to respect and honor my neighborhoods who I love so much. That's Treme and that's St. Roch. So I'm honored to represent those neighborhoods in New Orleans, and certainly honored to be a part of this panel conversation this morning with Secretary LeBlanc and Natalie and some of the others who I haven't met yet. And I just want to thank Angola Museum. I want to thank the Department of Corrections and everybody who came together to have a really important conversation. I'm really just inspired by the topic, the fact that we're able to try to unpack something that is incredibly complex and something that is very challenging for our state. But recognizing the fact that it is complex and challenging is the beginning, and it's conversations like this that help us work through these very difficult challenges. So when we talk about criminal justice, yes, it is one of the reasons that motivated me to go into public service. Prior to being in the state legislature, as you pointed out, Dr. Owens, I was serving and working with the Louisiana Supreme Court directly under then Chief Justice Burnett Johnson, who at the time was part of spearheading and leading Louisiana's efforts during justice reinvestment. That's something that Secretary LeBlanc and Natalie were at the helm of, along with Governor Edwards, right after he was elected, trying to get away from the notorious distinction of being number one in terms of incarceration rates in the country. And the challenge with that is that oftentimes those decisions that are made that lead to incarceration are not the responsibility of Secretary LeBlanc, because he is in many ways on the back end. It's a lot of pieces that are on the front end that lead to incarceration. But what are we doing while people are being detained and incarcerated to ensure that they don't come back? That's the other side of the coin. So it's a very nuanced puzzle piece that we're trying to work through to reduce that. And I'm not in a position to say where we rank today, whether it's 1, whether it's 2, or whether we're at 3. But I think we all recognize that we still have some ways to go. So I want to begin sort of my substantive commentary as it relates to just the overall population of this state. If anybody's been paying attention to the news, something pretty historic took place yesterday, and that is the fact that the Louisiana Legislature made the decision to override the governor's veto with respect to our congressional redistricting maps that we recently adopted. When I say we, that is me, because I'm collectively a part of the legislature. Although I probably don't agree with most of the decisions that come out of the legislature, yesterday being one of them. The legislature chose to override the governor's veto for probably a number of different reasons, but one of the key themes and reasons why the governor vetoed the congressional maps was because African Americans make up 1/3 of the state of Louisiana, population-wise. Actually, it's over 1/3, because there was a real undercount, but that's another conversation for another day. But the fact of the matter is that 1/3 of this state is made up of African Americans. However, our representation in Congress only ranks about 16 to 17%, because we have 1 seat out of 6 in our congressional delegation. The reason that I'm bringing this up is very important. You're probably wondering, why am I talking about redistricting? Well, when you talk about population, I tie that directly to our prison population. We make up 1/3 of the state's prison. We make up 1/3 of the state population, we African Americans, only 1/6 of Congress, but 2/3 of the prison population. So take those percentages: 17% in Congress, 66% in prison. That is a number that we cannot ignore. So race is directly tied to much of what is going on today, both in Congress, both in the state legislature, and certainly in our prison population. It's all very, very much connected to our state's history, being in the Jim Crow South. I think there's a lot to unpack, and people much smarter than me, much more intelligent than me, and people who have way more time than me can get into that. But I'll talk about it from a policy standpoint, what I'm trying to do in the state legislature to change some of that. So this year I have filed the bill. You pointed out, well, you didn't point out, Dr. Owens, but in the presentation, it was mentioned that Louisiana ranks the highest in terms of the number of those who are incarcerated who are serving sentences that will not have an opportunity for parole. I think that is a direct contributor to our high population rate, our high incarceration rate. So I've brought legislation this year. This is not my first year bringing it. I've brought legislation in the past, but this is the first year that I think we're going to have a real opportunity to have a serious conversation about it, and that will be to do away with these life without parole sentences. So we call it LWOP, And I'm looking forward to having that hearing very soon in the Criminal Justice Committee. I've also brought legislation this year to help try to streamline and improve our medical release, our medical furlough and compassionate release policies. That is another area of issue that we have to work on and try to improve. And again, I want to commend DOC because they've been at the table working to try to improve these challenges. And one of the things that I think in Louisiana that we struggle with is just a failure to confront the reality that as long as we make decisions around criminal justice purely out of anger and purely out of emotion, I call it lazy legislating, that we are never going to solve this issue. Most of the people who are incarcerated will be released, but there is a significant population that will not be released. And for those who will not be released, the state still has to foot the bill. So it's not an issue that we can run from. And if incarcerating everybody was the answer, then we should be a much safer state. But statistics shows that we are indeed we don't have statistics to show that we're any safer as a result. So we can no longer run from this challenge. So that's why I'm going to continue to bring legislation to try to push us in that direction, no matter how challenging it might be. I'm probably running up on my 12 to 15 minute time limit. But as a member of the legislature, as an African-American member of the legislature, I recognize the importance of trying to improve our criminal justice policies. We have a legacy in the state going all the way back to the non-unanimous jury verdicts that were in our Constitution that we just changed, going all the way back to Duplessis versus Ferguson, and all of that was in the video that we saw. And I think that we have a unique, we're uniquely situated, and I think we have to approach these challenges in very unique ways. So I'm looking forward to working with those who are on this panel, those who are working in the criminal justice system in Louisiana to try to improve it. And it won't happen overnight, but we're going to have to continue to have these sorts of conversations. So I'm grateful to be a part of it. And with that, I'll wrap up. You're on mute, Dr. Owens. You got to start working that mute button.
Okay, yeah. Thank you. Thank you very much. You really have about 4 more minutes, but you know, we can go on. Are there any questions from anybody in the audience? We haven't received any on that, but while we while we have this little bit of time, in terms of there's one question here that was presented before. We had some changes this morning. Okay, with the state legislature in session now, we are told that there are bills coming in to take away advances of the 2017 reform bills. What can be done, or better still, what is being done to mitigate to mitigate efforts to reverse these advances that we've already made?
Can you repeat that question? I'm sorry, Dr. Owens. I missed the first half.
Oh, okay. All righty. With the state legislature in session now, we are told that there are bills coming in to take away advances of our 2017 reform package. What can be done, or better still, what is being done to mitigate efforts to reverse these advances?
Yeah, no, very, very timely question. We saw some of this last year in 2021. We probably saw a little bit of it in 2020 as well. Right after, there had been a lot of bipartisan support for criminal justice reform back in 2017. But now in 2022, there has been a flurry of legislation, increase in penalties, new crimes that are being brought not just by those who you might typically expect to bring these bills, but you have, people from all factions, different caucuses who are bringing legislation to increase crimes and penalties. And I think that what we are seeing is what we've seen in the past. When there is an uptick in crime, not just locally or here in the state, but nationally, lawmakers and policymakers feel the pressure, rightfully so, to take immediate action to try to respond to any uptick in crime. And what that often results is in what do we do? What do we normally do when there's an uptick in crime? We resort to the same thing that we always do, is increase punishment, increase penalties, lengthier sentences, and the like. We saw that in the 90s, and we saw what the result of that was. We're still trying to undo the harm from all of that. So I understand the impulse and I understand the pressure, because I feel it every day. My constituents are asking, well, what are you doing to deal with the crime? I mean, it's awful what's going on in New Orleans. The problem, though, that we have to deal with is that we have to withstand the pressure just to make the easy decision to say, well, we're going to expand all of these crimes. We got enough crime laws on the books. We have enough punishment laws on the books. We have to work on front-end investment, and in terms of what we can do, we have to just continue to try to educate one another, to try to have the difficult conversations that investing in things like early childhood education, investing in things like increase in higher wages, better housing policies, better healthcare policies, all of the things that contribute to poverty and that contribute to the things that we know often lead to crime. Those are the real deterrents, in my opinion, and those type of social front end investments seem to be harder for my colleagues to want to take the time to invest in, because it's easy to go pass a bill to say, well, we're just going to, increase penalties, but there's no real data to show that that's a deterrent. It's much harder to say we're going to make long-term investment in early childhood education. It's much harder to say we're going to invest in mental and behavioral health services, and that we're going to make sure that when people come home from prison, that they're getting resources and that they're getting housing and that they're getting what they need so they won't go back to crime. And that's just, again, we're having the same conversation, but that's what we have to keep having the conversation, it seems.
Okay, thank you. We're inching up on the time that you have to leave, and we appreciate your.
Yeah, I apologize, y'all. I have to jump. I really wish I could stay for a longer portion, but thank y'all. I know Secretary LeBlanc's going to handle it. Natalie going to handle it. I didn't get to meet everybody on the panel, but look, I look forward to working with you all, and we'll talk soon. Thank y'all.
Secretary, Representative, I want to say before you sign off how much we appreciate having you at the Capitol, working with us. You're a big help to us, and I can't tell you how much I appreciate it.
Appreciate you. Thank you so much. We'll be in touch.
Thank you very much. Our next panelist is Natalie Laborde. She serves as the Executive Counsel for the Louisiana Department of Public Safety and Corrections, where her responsibilities include serving as the department's legislative liaison, overseeing policy development, review and implementation, coordinating the work of the communications team, implementing the state's justice reinvestment initiatives, and measuring reform outcomes. Ms. Laborde has many career accomplishments for which she can be proud, but her role in the development and implementation of the state's criminal justice reforms in 2017 and the resultant reinvestment efforts are reflective of the heart she has for addressing structural issues in criminal justice system while positively impacting the lives of Louisiana citizens. Ms. Laborde.
Well, thank you. I really appreciate that introduction. I just want to double check. I think Secretary LeBlanc was supposed to go before me because he was really teeing up kind of the background for justice reinvestment, but I may be wrong. I just want to double check.
No, I think that's right. I think I was, because mine leads into you.
Yeah. So
Okay, we got that. We got your introduction out of the way. So if you don't, Dr. Owens, if we could start my introduction and then I can move on.
So are we saying that you're going to speak now?
Yes, sir.
yes, sir. Yes, sir. Secretary.
All right. James LeBlanc,
Yes,
Secretary, Louisiana Department of Public Safety and Corrections. Jimmy LeBlanc has worked for the Louisiana Department of Public Safety and Corrections for more than 40 years. He has served as secretary for over a decade, being appointed to the cabinet position by 2 governors. After graduating from Southeastern University with a BA in business administration in 1972, he began his career in corrections in 1973 at the Louisiana Correctional Institute for Women. LeBlanc promoted through the ranks of the Department of Public Safety and Corrections, serving as Undersecretary, Interim Director of Probation and Parole, Warden at Dixon Correctional Institute for 12 years, and Acting Chief of Operations. Secretary.
Can y'all hear me now? Okay, I got it.
Yes, we got you now.
I got you. I got it. Thank you. So anyway, good morning, everyone. Natalie, Nicole, Dr. Owens, good to see you guys, even though it's virtually. And again, I want to reemphasize Representative Duplessis and his involvement in the reform efforts that we're working on. And I certainly want to thank the museum and the organizer of this event. I think it's very important. As already been said, it's something that we need to talk about and get on the table, if you will. And I'm happy to be here today to share my experiences and passion about Louisiana reform efforts. I began in my career, and as already been indicated, it's actually working on 50 years. It's hard to believe. And when I started my career in the early 70s, just a short time after the 1965 Voting Rights Act, which has already been indicated, an issue that remains a current topic in today's news. While Louisiana worked towards the desegregation of schools, I began a career in an occupation that focused on keeping people locked away in harsh conditions. Most people don't know this, but the current flooded out LCIW, I actually worked in a women's facility that was between the tracks and the river in St. Gabriel, which was an even older facility. Very harsh conditions for our female population. I can't deny that the early years were far less about individual rehabilitation and treatment and more about retribution for crime, security, and control. And I'm here today with a unique perspective and a committed passion, I assure you, because I've experienced and been a part of some of the most historic cultural changes in Louisiana's criminal justice system. I've been honored to serve as a secretary, as already indicated, since 2008, 14 years ago, through 2 governors. I hope that our legacy will be that we made a difference through commitment to humanizing the work of corrections through rehabilitative approaches and focus on reentry and commitment to reform. Reform is making changes to improve practice, improvements, and then measured by successful outcomes. Our panel here today will share with you what that looks like in Louisiana in recent years, where we have successfully passed and implemented historic criminal justice reform efforts. We ask ourselves, why reform? I personally believe that the primary measure of success for a criminal justice system is the ability to make the community safer. A key element to any criminal justice system is the incarceration of those who break the law for a period of time that is expected to hold them accountable for their action and reduce the risk that they may cause when they return. However, we must also recognize that sending people out of prison less stable and more dangerous than when they went in is not a productive approach. Research about what works and improvement in public safety has shown that incarceration cannot be just about housing and feeding, but must include opportunities for rehabilitation, education, soft skills, training, and most importantly, preparation for return to a community using a new skill set. And believe me, we could talk all day about these topics, but obviously the time allotted today does not allow for that. While Louisiana had to change the way it handles criminal justice, as Representative Duplessis indicated, what we are doing is not working. In 2012, our population in prison hit a peak of 41,000 prisoners in custody. Our incarceration rate was higher than any other state, any other country for that matter, and it was twice the national average. Yet Louisiana crime rates were still in the top 10 in all major crime reporting categories. And very simply, it's the right thing to do. We were releasing nearly 80% of our prisoners from local parish jails where they were being housed and fed with no or little access to programming or opportunities for change. Our prison population was churning. Our local level partnerships at 2439 a day and the caseload sizes for community supervision were feeding our system. Those housed in local jails and those not giving opportunities on supervision were becoming revocations back to prison. We were not making Louisiana citizens any safer by putting people in prison, and our prison beds at both state and local facilities were filling up. The history of reform, the first efforts to implement, and we don't talk about this a whole lot of justice reform, actually began in 2010 under the oversight of Louisiana Sentencing Commission, a multidisciplinary group of practitioners. And I have to mention that Cedric Richmond, then representative, became a congressman after that, actually passed a legislation to establish that Sentencing Commission. In partnership with Vera and JFA Institute, the commission identified driving factors to the Louisiana imprisonment rate. There was 3 areas: nonviolent, non-sex offenses accounted for over 60% of our prison admissions. Technical parole and probation violations accounted for 23% of our admissions. The use of parole was declining and the grant rate dropped in 2009, dropped by 56% from the previous year. So in 2011, the Sentencing Commission recommended the Louisiana Legislature pass and Governor General signed the first reform legislation to address these drivers. And that first one is targeting nonviolent, non-sex offenders. Act 160 provided decision makers in law enforcement and the judicial system with the discretion of waiving mandatory minimum sentences for nonviolent crimes. Act 168 and concurrent resolution 113 together, this package improves the accountability and quality of income quality of home incarceration and electronic monitoring with the goal of allowing more nonviolent, non-sex offenders to serve their sentences safely and productively in our communities. Reform targeting technical parole and probation violators. Act 104 created a system of intermediate administrative sanctions for offenders on probation and parole. Act 158 clarified provisions of newly enacted administrative sanctions law to ensure it is implemented as introduced by the legislature. And the third, declining use of parole, Act 186 and Act 110 revised the good time and earned credit statutes and calculations to improve the transparency in the duration of sentence. Act 123 repealed costly and underutilized risk review panels. Act 285 and 159 revised parole eligibility, authorizing the Board of Parole to consider first-time parole eligible offenders after serving 25% of their sentence. It decreased from 33%. And second-time nonviolent offenders after serving 33%, which was reduced from 50% time served. Then Act 153 improved the operation of the parole board, requiring members to complete initial and annual training, reporting requirements to DPS&C, conducting a risk and needs assessment for parole eligible inmates to provide to the board to review in making parole decisions. And lastly, Act 714 consolidated the Board of Paroles and Pardons into a single board to improve the effectiveness and efficiency of both operations and renamed it Pardon Board and the Parole Committee of the Board. While these early reforms were successful in many ways, they were not far-reaching enough to have significant measurable impacts on the state's incarceration rate and didn't provide the necessary programs to prepare individuals to return to our communities. Under Governor Edwards' leadership, efforts for reform were revitalized. With the same level of commitment to research for identifying drivers and possible solutions, the Criminal Justice Reform Task Force, then appointed by the governor, developed a packaged approach. This approach addressed drivers of our incarcerated rate while also humanizing the effects and outcomes of reform efforts for those impacted by the reform and the reinvestment of the savings. In 2017, the legislation consisted of 10 bills in a package signed into law on June 15, 2017. Very historic day for our state. The GRI package included 4 main focuses. One is focus prison beds on the most serious offenders, strengthen community supervision, clearing away barriers to reentry, and reinvestment of savings into recidivism reduction and crime victim support. which has been a complete success. This work has positively impacted our state's incarceration rates in ways we could not have imagined. And most importantly, it has afforded us the opportunity to invest in programs that are working to return prisoners to our community better than where they were when they came to us. Natalie will be sharing with you shortly the specifics of those legislative package and what bills that made up that package achieved. And Nicole is with us today, who will share some of our savings were allocated and have been invested in our grants, community and incentive grants. We have exceeded the projections for reducing incarceration in Louisiana and have been declared number 2 nationally here recently, second only to Mississippi, unfortunately. Still a lot of work to do, as Representative Duplessis said. Our state prison population is the lowest it's been in 20 years. Must give some credit to our local partnership with the sheriffs in place to provide regional reentry programs in 10 locations across the state. These programs are designed to provide reentry services to those returning to the 10 regions and 94 local jails statewide, where programming options are limited in some cases. We currently have 60 different programs offered in local jails as certified treatment and rehabilitative programs. And it wasn't that long ago we had 0. We have less people coming back to prison, and we're able to focus on ensuring the right people are in prison. Probation and parole is supervising less citizens today than it has since 2003. Caseloads have gone from 150 to 90. While we have a stronger community corrections program serving to help people succeed and spending more time with those that are less likely to succeed. For example, we have 11-day reporting centers statewide now serving the division for those who aren't doing what they're supposed to while on supervision, but aren't breaking the laws. Those programs help individuals work on soft skills, resumes, even at a high set, GEDs, applications, and ultimately connecting them to jobs. Our caseloads are small enough that our officers have more time to spend with those cases which need more attention and are at a higher risk of reoffending. What's next? I have to mention this. In the last year, we've established a new division within the department that will focus on diversity, equity, and inclusion for our staff, our prison population, and those who regularly interact with our department, visitors, volunteers, and all those who don't work directly for the department that approach our prisons. This team started strong last year with these first assignments around issues impacting staff, specifically recruitment and retention, staff training, and staff wellness. More recently, they have undertaken policy reviews to evaluate unintended consequences of policy and procedure that may cause disparate impacts. Some examples include visit applications, approval and processing, search procedures, and current work projects, including evaluation of job and program assignments to ensure equity and inclusion practices are considered. In closing, I want to note before Natalie and Nicole get into the measured outcomes of Louisiana reform and reinvestment efforts that we recognize and understand that COVID has had an impact on our criminal justice system. Clearly, this has had an impact on criminal justice in our state, and there is an impact on our justice reform as a result. It adds an additional layer to measure our success on our JRI efforts. However, the JRI work done builds a strong foundation for the future of our criminal justice in our state, regardless of these impacts. And while we may not have seen the reduction levels we have experienced in the last 2 years with the addition of COVID, I am confident that we will have a reduction. I anticipate we will continue to reap the rewards of this work for the long term as we meet our JRI goals. And with that, Dr. Owens, I'll turn it back over to you. And I think Natalie's already been introduced, so I don't know, maybe I want to just work right into it. Thank you.
I don't see a problem. I don't see a problem with that. Natalie, go ahead.
Yes, sir. Well, thank you. Thank you, Secretary LeBlanc. And I really just, before I even go into the details about the actual criminal justice reforms that were passed in 2017, I just want to reiterate, I came to work for this agency specifically to work for Secretary LeBlanc and his vision that he had for reforming the prison from within the inside. I got to know him in a previous job role, and I was really amazed at just what he was doing to expand programming within the state facilities and local jails at a time when all of state agencies were being significantly cut. So he was very creative and found a way to invest money rather than cut it, and then still actually see a savings. And there's a lot of grassroots work that went on prior to 2017 that he touched on a little bit, between the Sentencing Commission and judges who were involved, and prosecutors, defense attorneys, people who really took this on at a grassroots level. And he wouldn't say this about himself, but Secretary LeBlanc really led that initiative long before this was something that was, I think, a priority topic in our state. And it's been it's been a great honor to help to come on board and help continue that work. So as he mentioned, that 2017 was historic for our state in terms of criminal justice legislation. And that came off the back of in 2016, there was a task force created that Representative Duplessis mentioned earlier. That was the Justice Reinvestment Council. And it was made up of a membership of what I like to call heavy hitters, in that you had the Chief Justice of the Supreme Court, you had the chairman of both the House and Senate criminal justice committees, you had judges, you had representatives, and everyone actually participated in every meeting. You know, just Louisiana has a ton of boards and commissions and task forces, and a lot of times people send proxies, but we met for a year, and Secretary LeBlanc was the chairperson of that task force. And we also received the technical support from the Pew Charitable Trust Foundation, who came in and did the largest data extraction that had been done in our state and in our criminal justice population, to really help the task force look at some of the more nuanced components of our population and what the drivers are, what offenses people were coming in for, what offenses people were being revoked for. And so they issued a report to the legislature and to the governor prior to the 2017 session, making pretty expansive recommendations on how to reform the system as a whole. Now, as with any major legislative package, there was, of course, some negotiations that had to happen throughout the process. And so some things we were not able to accomplish, and those relate mostly to changes regarding violent convictions. We made a few little small changes, which I'll mention in a little while, but the majority of these reforms on the sentencing side related to nonviolent offenses, opening up parole eligibility, expanding opportunities for alternatives to incarceration, so a judge can put someone on probation rather than prison. So there is still some work left to be done in the area of the violent offenses and life without parole, as Louisiana very much is an outlier in that. But nonetheless, the 2017 reforms were historic, and I believe that we will continue to build on that reform. So just going back to, as Secretary mentioned, when we that task force, and what really the data showed us is that the major drivers of our population at the time, we had the highest imprisonment rate in the world, and up until around 2010, our population had been growing roughly 1,000 every year. So that had stabilized, but the preliminary drivers were we housed nearly half of our state population in local jails, and that was a policy decision that was made 20, 30 years ago to help with some of the decrowding issues. It's probably seemed like a short-term fix at the time, but it developed into something I don't think anyone ever imagined. So again, being spread out across, I think 100+ local jails and just minimal programming there was adding to the recidivism. We have very archaic sentencing and penalties, just a lot longer possible penalties for nonviolent offenses than other states. And then also at the time, roughly 60% of our intake, so new offenses, were coming from revocations on probation and parole. So meaning people either spent time in prison or they were given probation and they weren't being successful. So we knew that those were the areas we really needed to try to focus on. And Secretary mentioned the focus of the JRI, which is to reduce the prison population safely, reduce the use of imprisonment for violent and dangerous people, strengthen probation and parole and supervision, and hold people accountable, but also give alternatives to incarceration. So in terms of the actual legislation that passed, it was 10 bills. I won't get into the act numbers. Those are all available in our annual reports, but I'll give you an overview of what those bills did. So the first category is reforms to sentencing. So the penalties that people receive for certain crimes, or alternatives, giving judges more discretion in what they give someone as a penalty. We increased the opportunity for probation instead of imprisonment for those nonviolent offenses with 10 years or less. So I think prior to the reforms, if it was a second offense or later, a judge didn't have the discretion to suspend a sentence and put someone on probation, but we increased that to third and fourth offenses. We reduced the penalties for simple possession of drugs. So that was one area we were so significantly out of line with other states. And again, moving towards that model of treating simple possession, not people who are possessing. We're not talking about dealers or manufacturers as an illness and something that people need treatment and services for, rather than just the automatic penalty of putting someone in prison. Created a felony class task force. So when you look at Louisiana, our criminal code is about 3 inches thick, where some states it's about 20 pages. And that's because they have class systems. So categorically, crimes fit into a different class and they all have similar penalties. We don't do that here. That was a push we tried to do in the reforms. That is something that we got a lot of pushback about, just because of the change made broadly to offenses. So a task force was created to review it instead of actually to a felony class system. We narrowed the application of the habitual offender statute. So you've probably all read articles about how Louisiana sends a man to prison or a woman for life for a simple possession. And the way that can happen is because someone is being multi-billed. So a habitual offender law enables a prosecutor to enhance the penalty of what would otherwise be the penalty for a crime. So if the crime allowed for like 10 years, if you had previous convictions and they multi-bill you as a habitual offender, they could give you 20, 30 years and sometimes up to life. So we worked with the DAs very closely, the task force did, to rein that in. And so now it's much more limited. If you have all nonviolent offenses, you can't be multi-billed and given a life sentence. And the data even shows, I mean, to the credit of the prosecutors, that's being significantly reduced in when they choose to use it, and used now really what it should be used for, as a tool in individual situations where you have someone who's habitually committing crime, but not just across the board to just raise penalties for everyone. And then we limited the max amount of time someone can get from probation from 5 years to 3 years. There's of course some circumstances where the judge can extend that beyond, but the baseline max is 3 years. The second major categorical changes were changes to parole eligibility and good time. So Secretary touched on some of the changes that were made prior to 2017 by the Sentencing Commission. And these changes really built on that. And it expanded parole eligibility for all nonviolent offenses to 25%. So there's, no matter what, if you're serving on a first, second, third, fourth, fifth, it's after 25% you can be considered by the parole board for parole. It doesn't mean you'll get it, but it, again, looking at the length of our sentences compared to other states, this was an opportunity to open up some options for people for release. And that applied to people who were currently in prison, so not only prospective but retroactive. We did change the rate for violent offenses to 65% instead of 75%, but that was only any new convictions prior to after 2017. Good time calculation in Louisiana. It's again, I'm sure you've all heard how complicated our laws are. So we also have another way most people release, and that's called good time parole. And it's pretty much just you earn automatic credit towards your sentence just by good behavior or not committing rule violations. And once you hit your projected date, you release onto supervision. You don't go before the board, things like that. We changed the rate for that to enable people to get out a little bit earlier as well. Again, that was just trying to put Louisiana in line with other states and how long people are serving for nonviolent offenses. One big change was creating parole eligibility for juvenile lifers. So there were a couple Louisiana and United States Supreme Court cases that found in the late 2016 to 19, or excuse me, 13 to 15, that you can't automatically send a juvenile to prison on a life sentence without parole. You can give them a life sentence without parole, but it can't be automatic. There has to be an individual assessment. So creating parole, the possibility at 25 years, if they meet all this other criteria for juveniles who are sentenced to life without parole. Medical treatment furlough. So Representative Duplessis touched on this earlier about the need to look at ways to release people based on their medical conditions that are very significant, that could otherwise be treated safely in a care facility. So we created a new type of medical release called medical treatment furlough. It's a little bit different than the existing medical parole, which excludes people who are convicted of a 1st and 2nd degree murder. Medical treatment furlough allows 2nd degree murder convictions to be considered. And if you qualify and you are approved by the board, you can go to a long-term care facility. And again, just utilizing better facilities and medical care or locations instead of treating prison as a hospital, essentially. And then lastly, one of the major changes, it was a small population, but I think it has an individually a large impact on people's personal lives, but it really has set the tone for the argument to continue to open up doors for life with parole. So there were a group of, we call it the 1970s lifers in the 1970s, and we really discovered this through our task force meetings. Someone brought to our attention that in the 1970s, the law, if you were given a life sentence for 2nd degree murder, you actually had the possibility of parole after serving 20 years and then a little bit later 40 years. But the legislature came back and changed that and made life means life without parole. And so we had a group of people who were caught up in that change, where when they went to prison, there was an expectation of parole. That meant their victims also had an expectation that this person may be released on parole one day. So we were able to restore that for this group. And the prosecutors were on board with this, and it's gone so well. I don't have the stats in front of me, but we have essentially a 0% recidivism rate of over, I believe, 70 to 100 have been released on that. And I may be wrong exactly on those numbers, but more than anything, what that shows is that this population as a whole is worth really considering as a state, as a policy change. And again, it's not saying you won't do a life sentence. It's just saying 30, 40 plus years. Let's revisit this situation and see what a person has done to rehabilitate and change themselves and make amends, et cetera. So those were the major changes for parole and releases. Next, the other major area that the legislation dealt with was community supervision. So trying to give probation and parole better tools to help people stay successful. And that's a real big one of Secretary LeBlanc's major priorities of the last 10 to 15 years has been shifting the culture in probation and parole. That success means helping someone stay as an agent, stay out and successfully transition back to the community, not trying to find something you're doing wrong to lock you up. And we've really seen so much change in our culture with that. So this gave them more tools. It's called earned compliance credits. So just like we have good time in prison, if you have good behavior, you can earn time off your sentence. This is if you comply with the conditions of your supervision, you can earn time off of your completion date. And that has been an amazing tool for probation and parole. It's what's helped us see the reduction in the overall caseload, helping people terminate and get off the caseload who are doing what they need to do, and allowing probation and parole to focus in on those people who really do need a lot of attention and supervision. And then lastly, or not lastly, one of the other areas is reducing barriers to reentry. So, I mean, that's a big topic in criminal justice reform as a whole, that a lot of times people, they're sentenced, no matter if you're off paper or you're done with your supervision, you're out of prison, it seems like it's still a life sentence because there are so many barriers you now face in the community with having a record and getting a job or getting certain government benefits. It's just a very, or connecting with employers. So we tried to address some of those with fines and fees, some changes to that, allowing judges to tailor fines and fees based on people's income and what's reasonable for them. Child support, the ability to suspend that just while a person's in prison. And again, that's not to absolve someone of a responsibility to support their children, but it just suspends. And then when they release, that obligation continues, and the time that you were in prison, you got to make up for that whenever you get out. So it's not like it just gets wiped clean. And then opening up, there was an old law on the books that said that if you released from prison with a drug offense, you could not get SNAP benefits. And I think that was back during the tough on crime era, but we were able to remove that restriction as well. And then lastly, the major area, and that really segues into the next area of the presentation, is the statute mandated that savings that were generated and realized from all these changes, the reduction in the population that we would see, would not just be swept up and put back into the general fund, but they would go back to reinvesting in changing and improving the criminal justice system. And specifically, it mandated that, okay, each year the savings realized, which is measured by the reduction in the population, 30% of it goes back to the general fund, and then 70% of it is reinvested back into Department of Corrections, Office of Juvenile Justice, prevention programs, community incentive grants, which Nicole will talk about a little bit later, and then crime victims services. So,
Natalie, can you wrap it up?
Oh, I'm sorry. I was trying to watch my time. Well, I'm already there. We've been able to roughly $130 million overall that we've seen realized, and those been reinvested and back into DOC programming that Secretary mentioned. And then another primary area is community incentive grants. So partnering with reentry organizations to help people when they get out. And with that, I'll hand it over to you to introduce Nicole, who's going to talk about that.
All righty. Thank you very much. Our next panelist is Nicole George, Justice Reinvestment Initiative Coordinator, Louisiana Department of Public Safety and Corrections. Nicole George serves as the Justice Reinvestment Initiative Coordinator. Prior to her work with JRI, Ms. George served as Program Manager for the Office of Behavioral Health and with the Louisiana Department of Health and Hospitals. She also worked for the Louisiana Housing Authority for 10 years. She obtained her master's degree in organizational leadership from Regent University and a bachelor's degree in business administration and management from Southeastern Louisiana University. Nicole.
Thank you so much. And thank you again for allowing me to be on this panel. I know we're running up on time, and I promise I won't bore you too much with the details, but I wanted to talk about the two main programs that we run out of the community incentive pot of money that we have received from Act 261 that Natalie just mentioned. So the first program is called just basically the Community Investment Grant Program, which essentially is the big pot of money that we have allocated to what we call Tier 1 and Tier 2 parishes in the state. These parishes have been previously identified as incarcerating the most returnees back to their communities. Just to run through them real quick, the top 5 would be Caddo, Orleans, East Baton Rouge Parish, Jefferson, and St. Tammany Parish. And then what we call the Tier 2 parishes would be Bossier, Ouachita, Rapides, Calcasieu, Lafayette, and oh dear, I'm really drawing a blank. I really apologize. Terrebonne and La Pouche. Whew, that was scary. And what we have done in those areas have done what we call a competitive process in order to award those grant fundings. Each year we do what is called a notice of funding opportunity to interested nonprofits and judicial districts and local government agencies who are interested in partnering with us to get additional funding to help those that are returning back to those communities within 6 months pre-release and then up to a year post-release to help those returning get back on their feet. The main priority at this time has always been the case management. So we allow our community partners to go into the facilities, mainly the regional reentry centers in their respective areas, to go in and talk to the eligible participants to see if they're interested in participating in the program And those who would be eligible are those that we have identified as moderate to high risk of recidivating, according to the Tiger Needs Assessment, or if they are a low risk person, but they have high needs whenever it comes to returning to their community. So once we have identified someone that would be interested, we partner them with the nonprofit, and they are allowed to go in and have that open dialogue on what those needs are going to be post-release, whether it be housing, family reunification, just mentoring post-release, employment, housing, things of that nature. They start to get those ducks in a row pre-release. So when they actually do release into the community, they can have a couple of those things lined up. One of the big things has always been housing and transportation. So our partners really help them secure those things. So whenever they leave our gates post-release, they can go immediately into housing if they're in need of housing, or if they're in need of transportation, things like that. They're able to directly link those items for the participant. The other thing that they do is closely monitor them for up to 6-9 months, sometimes a year, just to make sure that they stay on track and they don't fall off the wagon, so to speak. That becomes extremely important whenever it comes to the recidivism rate, because we all understand that if you don't have that support system, whether it be family or just a community at large, you're more likely to return back to incarceration. So we encourage our providers to make sure that they stay in contact with their case and make sure that they have all their needs met. And if there's anything that they are lacking or that they need, they do reach out to other community networks, largely known as reentry coalitions at the parish level, that can help them connect and network to get those things fulfilled, like things like substance abuse, or if they have a welding certification that they received while they were incarcerated. Do we have an employer in the area that is in need of a welder? So they try to really network to make sure that all the person's needs are met. Now, with the other program that we run is called the Emergency and Transitional Housing Program. It is a statewide program. We partner with existing transitional houses or homeless shelters, and we pay them a set per diem up to 2 weeks for emergency housing or up to 6 months for transitional housing. And this allows those who are on PNP supervision to really get back on their feet and concentrate on saving funds for deposit and rent versus using those funds immediately and being homeless in the meantime. So we work with our PNP partners at all the district offices. We connect them with the ETH housing, and we make sure that the person that won't be homeless, and we get them connected to that housing provider. It's a statewide program. We mainly serve the Tier 1 and Tier 2 parishes that I mentioned earlier. However, any parish in the state that has transitional housing, they do have the opportunity to apply to be put on our list. We do open that cycle twice a year, in the spring and in the fall. And if anyone's interested, definitely go to our website, the JRI page, where I have additional information on both programs. And if you're interested in becoming a transitional housing provider, my information is on the website that I can add you to our interested parties list. So whenever we do open up the application cycle, you are more than welcome to apply. I know I ran through that really fast, and I truly apologize. But again, I really appreciate the opportunity to explain both programs that we have. Oh, I think you're muted, Dr. Owens.
Again, all right. We're at the point now where we have some questions from our participants, and we'll start with the first question. What are the numbers of prisoners who are able to participate in the training programs that have been talked about earlier? Secretary LeBlanc, I think that might be your question.
Yeah, I'll make attempt at answering that. If we'd like to get to more of them. The state prison system obviously has considerably more opportunity at that state level. As I mentioned earlier about the regional reentry programs. Our goal for the local level to go through regional reentry programs is 6,000. I don't think we talked about the details of that and how many people discharge out of our parish jails. And I'm a firm believer that that's been a real drive in our incarceration rate, that 80% of the people that discharge out of our parish facilities, which is somewhere around 12,000. So we're not getting close to where we need to be, but we are working our way towards that on these reentry centers. At the state level, if you apply yourself and you do what you're supposed to be doing at the state level, you have an opportunity to participate in programming. So we discharge roughly 4,000 out of our state prisons, and every one of those will go through at least a 100-hour pre-release program. And then the majority of them get an opportunity to get their GED, a high set, and get involved in literacy, reading and writing. We have a multitude of vocational programs at all of our facilities and I need to indicate, and I mentioned that at the end, that COVID has had an impact on that here in the last year or two with not being able to do things that we normally do. But we're back in full swing just about in visiting and opening up programs. We don't have any positives at the state level. And I think we're about at zero at the local level as far as COVID is concerned. I hope that answers the question. So we still have a ways to go with that. And that's the reason Probation Pro becomes a key component of that. When they do get out, we like to direct them in an area where they can get access to programming. And as important as Medicaid cards, Medicare card, the cards, 70% of people discharging now, if they go through a reentry center or through a state prison, if they're eligible, they have a card so they can get access to programming from a mental health standpoint, from a medical standpoint, in particular for drug treatment and those sorts of things that happen.
Mr. LeBlanc, on the same, while you're up, there's another question that came up that's directed to you. Would you consider one good time law that everyone would fall under instead of 10 different ones? Like every 30 days served, that person can receive 30 days of good time. I hope you understand it.
Well, yeah, and I don't know that we have 30 good time laws, but we do, as Natalie said, and I have a copy of it right here. I can throw it up on it.
But the question mentioned 10 laws.
This is our code right here. This is how complicated things are. But good time, and look, I guess, from my perspective, personally, I think a person who has a violent offense shouldn't be eligible for as much good time as a person with a non-violent offense. That's kind of how I feel about it. So that's where the differences are. I think Natalie can probably handle that better than I can. Natalie, I'll kind of throw it your way.
Sure, yeah.
And that attorney came out in her, and that's why she was speaking over her time. I just want to.
Oh, I took your job, Secretary. The time. So I think what they're referencing is, yes. So in general, there's a one rate right now going if you're convicted for nonviolent and one rate for violent. But again, what applies is the law that was in place at the time that you committed the crime. And so we do have people in our population now who are, it may be a different rate than what the law says now. And so it very much overcomplicates. I think there was some discussion to your point about one rate, but to me that would have a negative impact, because unless we reduce the sentence lengths for nonviolent offenses, if we across the board do a threshold one good time rate, that's going to mean people are going to be serving longer on a nonviolent offense in prison than they would right now. So that's the caveat. I don't think we can do one rate for violent and nonviolent unless we reduce the overall sentence lengths for nonviolent offenses. I hope that that's helpful.
Okay, thank you.
And Dr. Owens, if I could.
Go ahead.
I think this is important to note that, we talked about what we did prior to Governor Edwards and what we did during the Edwards administration. So we kind of built on what we did earlier. So you have to bring the crime victims along with you in this, and that's important. And that's what we've done, I think. And so and as Representative Duplessis said, it takes time. It's a very complicated deal. This is not as simple as it looks on the surface, or may look. But we gotta do this in stages. I think so far we've accomplished quite a bit since we started the reform efforts, and but we have a ways to go. And I'm a firm believer that, as Representative Duplessis said, that the life of population is one area that we need to really consider on becoming parole eligible to some extent here. But anyway, I felt like I needed to say that.
That's fine. That's a good response. Natalie, another question is focused on you. How successful have your reform efforts been with parole eligibility for the group of juvenile lifers?
Yeah, that's a great, I saw that question because I talked about the 70s lifers and how the recidivism rate has been, and roughly the same thing, very successful. I think they've had roughly 108 that they've had hearings for the juvenile lifers, and 78 to 80 around that have been granted. And I want to say 1 or 2 maybe have recidivated. So again, very successful. And the parole board's going to have the most accurate data on that. But the bottom line is they have also been a great example of what these long-termers, when they transition back, and also the judgment calls of the parole board and what they're looking at when they're evaluating whether a person should release after serving that long of time.
Okay. As we all know, the non-unanimous jury was one of the last vestiges of Jim Crow laws. In 2018, Louisiana voters overwhelmingly approved Amendment 2, which requires the unanimous agreement of jurors to convict people charged with felonies. However, the measure applies only to crimes committed on or before 2019. What is being done for those who are already convicted by a non-unanimous jury? Anyone, please.
I can jump in, and honestly, Representative Duplessis is probably the best person to speak to this because, as he mentioned, DOC is really just we carry out the laws as imposed. But to clarify, I believe it's that the changes apply to anyone convicted 2019 and going forward. I believe there's been a couple measures, legislative measures, to address the population that previously were convicted under non-unanimous. Ultimately, the Supreme Court, I believe, found that the new law wasn't retroactive. Nothing passed last year. I'll be perfectly honest, I'm not super up to date. If there's any legislation this session, I would assume there is to deal with that. But I know individually within the population, people are working with their attorneys on the possibility, of requesting new trials, et cetera. But to me, the primary way to address that group is going to be a legislative. And so hopefully we'll see some legislation that speaks to the convictions prior to 2019.
Okay. Secretary LeBlanc, would you discuss prison labor in Louisiana today and solitary confinement? What are some of the things that are going on with prison labor? Unmute.
Okay.
Yeah. Go ahead.
So we have the segregation task force that we're working with currently that was done by the legislature, working on that area. But we closed Camp J. I'm talking segregation now. we closed Camp J. That was a nightmare that we needed to close. We've done that. We have just recently in the last several months passed a new regulation that allows people to spend 2 hours or more out of their cell with programming, all the things that we need to do to address the mental health side of things. I'm a little bit limited on what I can say because we are in litigation on that at David Wade, but we have made a lot of progress. I don't have the numbers in front of me, but I know we've reduced the number of people in restrictive housing by a couple of thousand over the last couple of years. So we have a matrix now in our disciplinary where people know how much time they're going to spend when they are assigned to a segregation unit. So we're doing everything we can to improve that because we realize the mental health aspects of that and what impact it has. And certainly we know we need to continue to improve in that. That's one of those things that we'll continue to work on and move forward. And what was the other part of that, Dr. Owens?
It was to address solitary confinement. What's going on in that?
I mean, that's the solitary confinement. Was it labor? Was that?
Yes, prison labor.
Prison labor, yes.
Well, we think people being busy and staying busy at work is important, both for everybody's safety. As we all know, that, when people are a little bit tired when they go to bed, I think it's a good thing. We're doing the best that we can to make it work that they can use and learning how to be on a job. So, that's something that has created a little controversy on the issue of slave labor. We want to get away from that. Obviously, if there's any indication of that, we try to work with volunteers that want to get out of a dormitory and get out and being able to do some things that are productive and not have to force it. That creates problems for everybody when you do that. That's an area another area that we're working on and I think improving. And we'll continue to, with the job efforts, the reentry court program, the specialty courts are working well with that, where people are getting jobs when they get out. Before they get out, they have to have a job. That's participating in programming, which is considered work. So we're doing the best we can with that. I assume that probably helps answer the question.
Oh, yes, thank you. Here's a question that was brought to our attention by by someone who had registered for this seminar. If we can raise and lower prices for gas, food, housing, etc., according to economic changes, why not do the same with bail, fines, and fees? And as an add-on to that, you think about, for instance, someone who is arrested for DWI. They're not going anywhere. Most of them are not. And I know there's some precautions you have to make with, letting people out. What are your ideas on the focus of this question?
Natalie, I don't know if you want to talk about that a little bit. It's kind of like she indicated earlier, Dr. Owens, that we're kind of the keeper of the keys in a sense. We're not that involved in the upfront stuff. I think what I read about and we're not involved in that legislatively. That's something that needs addressed. I certainly believe that. I think they are trying to address it. Natalie, I don't know if you. I don't know.
Yeah. Secretary mentioned, I would say 2 things on the front end, part of the JRI reforms, and it's taken some time to ramp up. I know they've extended the effective date, but the tailoring of fines and fees. So giving judges the ability to look at a person's ability to pay their income, et cetera, and perhaps, reduce fees or eliminate them that otherwise are a part of that criminal penalty. And then as Secretary mentioned too, that the bail side, again, that has been extremely, controversial for the last 10 to 15 years that I can remember here in Louisiana with any push to reform it. Because I think you have a lot of industries weighing in. But it's a very real area that needs to be addressed, in my opinion, just with the reality when someone's arrested. And if the only reason that they can't get out prior to their trial, or is a financial reason, versus it needs to be limited to public safety, in my opinion, because just the ripple effect that happens with someone, if you haven't been convicted of the crime, but you're in and you lose your job, I mean, it essentially creates, a series of other very bad situations that ultimately could lead someone to commit more crimes if, they were in fact guilty to begin with. But there's been a lot of push, I would say, over the last 10 to 15 years, and not probably a lot of headway made, but I've definitely heard, through the criminal justice channels, that is an area, the next area of focus for a lot of these grassroots organizations that helped push criminal justice reform as a whole, that their next area of interest is the front end pretrial bail reform side of things.
The one thing I'll mention too, Dr. Owens, to whoever's asking the question, that came up in our first sentencing commission. I remember that was starting to talk about, and look, we were going to lose a whole reform effort because of that. And we had to drop that. I mean, it was a real hot topic. That's settled down a little bit now, but back then it was a real hot topic. And I don't know all the intricacies of that, but as Natalie indicated, it's something that needs to be addressed, and it ought to be a public safety issue, nothing more than that. I'm with you on that.
All righty. We have another question here. Will the jails in Louisiana ever not house people who are serving DOC sentences? Again, Secretary LeBlanc.
So, our prison population has gone from that 41,000 that I mentioned earlier, 40,170 in 2012 when it peaked, to 26,000. And that 14,000 decline, we've had some decline at the state level because of COVID, and having places to medically isolate people, having dorms where we could put them, so we couldn't have a full capacity. But probably of the 14,000, 13,000 of that has been at the local level. We have closed, I'm guessing a little bit here, somewhere around 10 or 12 local housing areas. Some have converted to ICE, where we're not housing state inmates in those locations anymore. I'd like to think that we can convert where we are facilities into more like state facilities. And that's what our goal is to convert them where you don't have the construction costs, but let's invest in these facilities so they can provide the programming that they need before they discharge. So we did that regionally, and we are doing that to some extent at local jails. I mentioned, I think we have 44 different parish jails now that have some type of programming. May not be enough, obviously, but it's a step in the right direction. So I don't know that we'll ever get out of that business. I guess that would be our goal, that we continue to reduce our population, but as we reduce it, it is at the local level. That's where it happens.
Okay, thank you. Do you find many employers who are willing to hire parolees? And if so, what types of businesses?
Well, that to me is our biggest challenge. We started what I call an outlaw program, where employers can now get online and actually interview a prisoner before they release. They can fill out an application. They can go through the process. Statewide, I think the last time I checked, we had 44 employers that had signed up for that in the state. That's not a lot. That's the challenge we have. I think that was mentioned in some of this, this life sentence, when you get out of prison now, it's almost like your sentence continues when you have that on your back with, being a prior incarcerated person. That's a challenge that we're faced with. Proof's in the pudding. The Louisiana Parole Project, they lead by example. They are finding jobs. They are doing the right things, and that shows success. So our transitional work program, somewhere around 1,800, maybe close to 2,000 now. It's coming back. It needs to be at 3,000, where we have guys that are working still in prison, but are going out to work every day, making a prevailing wage. And so those employers, I mean, they love it. They love that operation, and they like people that are coming to work sober and ready to go to work. You know, that's how it works. So we have that side of the employers, but you know, we don't have enough of them jumping on board when they discharge. There's a few of them that allow them to stay on the job, but not enough. Employment is our biggest challenge today, in my opinion. We have gotten through a lot of the other things, but employment is an area that we work with lobby, we work with, you know, we're trying to get people on board with this. It just takes time, patience, and we'll continue to do that. The more successes we have, the better that I get. And we are having some success.
Okay, certainly there are people who are below grade level in the, you know, in terms of these jobs. What types of jobs are available for those people who are below grade level?
You know, right now, if you want a job, you can, you know, in that area, they got, you know, you can't, you know, when you go anywhere now, you know, even in restaurants, you know, tables are shut down because they can't find enough people to work. You know, those are the kind of things that you would think we would have better success. When you say low grade, I'm assuming you mean those that don't have education that.
Right, exactly.
So
yeah,
we, you know, we do the best we can with that. You know, and you know, we try, you know, work release kind of drives that a little bit. Unfortunately, they're working in the fast food industry, the restaurant business, maybe working on the construction, you know, with labor type jobs, that kind of stuff. That's what comes to mind.
Okay, along those same lines, how do you encourage local facilities to develop good reentry programs that include job readiness and connections?
Well,
what are you doing in that area?
$26 a day does not give them enough money to do that. They have to have the resources to do that. And that's why we did it regionally, because we were able to invest the funding for them to ramp up. We've done that a little bit in partnership with the technical college system, with, you know, with the people that are helping us in partnership with educating people through our vocation, what I still call vocational programs. So we, you know, it becomes a money issue, a resource issue. We have placed transition specialists out in the jails that we have funded in partnership with the sheriffs. They're out in different locations and working with the population there. And Probation Pro plays a role in this. You know, they have to be involved in those that are discharging at the local level before they discharge, helping them transition and working with the sheriff so they have some wraparound service, if you will. And what Nicole talked about with our community programs in those areas, that's helping. Unfortunately, it's not statewide, but we're working on that.
Okay, we have two final questions as we march into the end of this program, and I'm gonna just ask these questions, and if y'all could briefly answer them so we could stay as much on schedule as we can. For terminal ill persons, how are they facilitated other than in prison? For terminally ill persons.
Medical parole, medical furlough, and compassionate release. That's what we look at. There are limitations with, I think, and Natalie, you help me here, first degree and second degree murder aren't eligible in most cases. I don't even, not even, they changed, that was a step back, I think, on compassionate release. I think they stepped that back.
On medical treatment furlough. Yeah. So yeah, there's the three he's mentioning. One, compassionate release, actually secretary, if someone's in the last 60 days of their life, he has the ability to compassionate release. Now, that is used very conservatively. And the reason is that, again, that is a unilateral decision made by one person, the head of this agency. It's not something that goes before the board where a body look at this and review. So you know, that we exercise a lot of caution in considering the nature of the crime, sex offenses, et cetera, but he does do compassionate releases for people who are terminal and in the last stage of their life and have appropriate place to go to for hospice. And then the other two mechanisms go before the parole board for consideration. So it's a medical evaluation and then also a public safety evaluation. And that's usually people it's people medically who are either completely incapacitated or they're within like a terminal lifespan of a year or around a year. And again, it's not just purely a medical evaluation. There's also a public safety component, and then, you know, victims and prosecutors and weigh in as well, law enforcement.
Natalie, this final question is directed to you, so you'll still have the stage here.
Okay.
You mentioned the successful recidivism rate for the juvenile lifers who have been released. How many juvenile lifers are still in prison? And how many went before the parole board but weren't let out?
You know, and again, I'm not the best resource for that. That is the parole board, but the most recent numbers I had, I want to say of the 100 that have been heard, 30 were denied, I believe, around that. And I'm not, maybe a couple, 100 or 200 that are still left in the population. I can certainly follow up on that, but Francis Abbott with the parole board is the primary source for that resource.
Okay. Panelists, thank you very much for the time that you've given us on this program. And I just, again, we want to applaud the Angola Museum for facilitating this and opening this up like it has done. And I know how hard they worked to get this program off, and there was a lot of moving parts to it. And with that, we'll close.
Yep. Thank you so much. Yeah, thank you so much, everyone, for attending today. Thank you, Dr. Owens, as well as our panelists, Mr. LeBlanc, Ms. George, and Ms. Laborde, as well as Representative Duplessis. We appreciate you guys taking time out of your day to be here with us. And just a reminder for all of our attendees, tomorrow is our final panel. Tomorrow at 10:30, we have a great panel lineup. So we hope to see you there. Thank you all. Have a great day.